food. Clerk, please read the motion.
That Regulation EU 2023/2419 of the European Parliament and of the Council of the 18th of October 2023 on the labelling of organic pet food should be added to the Windsor Framework by the United Kingdom and by the European Union within the Joint Committee in accordance with Article 13(4) of that framework.
I call the First Minister to move the motion. Thank you. The Business Committee has agreed that as this motion relates to legislation, there will be no time limit on the debate. Please open the debate on the motion.
And just before I start, can I please have the opportunity to wish offer my condolences to the family and friends and colleagues of Stephen Grimison at this very difficult time. There's no doubt that Stephen made a huge contribution to journalism here and was front and centre of some of the biggest moments in our political history, including at the time of the signing of the Good Friday Agreement. A much respected Director of Communications for our executive, and no doubt will be missed by all those that loved him and knew him, so I just wanted to put that on record on behalf of the Assembly today. The Deputy First Minister and I jointly table this applicability motion that Regulation EU 2023/2419 of the European Parliament and of the Council of the 18th of October 2023 on the labelling of organic pet food should be added to the Windsor Framework within the Joint Committee in accordance with Article 13(4) of that framework. The Speaker informed the Executive Office on the 28th of March that the notification of a new EU Act had been received from the British Government's Windsor Framework Task Force. This new Act, Regulation EU 2023/2419 of the European Parliament and of the Council, relates to the labelling of organic pet food products and is the subject to the applicability motion process set out in the Windsor Framework Regulations 2024. The notification was accompanied by an explanatory memorandum drafted by the Department for Environment, Food and Rural Affairs. The Speaker has shared both the notification and the explanatory memorandum with the Assembly. This regulation was adopted by the EU on the 9th of October 2023, entering into force on the 30th of October 2023, with the new provisions being applicable from the 1st of May 2024. The regulation extends labelling and production requirements that are in place for organic food for human consumption and livestock feed to organic pet food. The EU is seeking to apply the measure using the process set out in Article 13(4) of the Windsor Framework, and as such it would apply here only if agreed in the UK-EU Joint Committee. The explanatory memorandum explains that the regulation would extend the same labelling requirements to organic pet food as currently exists for other organic food. This means that pet food would need to be produced with at least 95% organic agricultural ingredients to be tabled as organic. It is highlighted that producers here currently have to comply with more stringent regulations in order to ensure that their pet food can be marketed as organic, identifying challenges due to the lack of availability of appropriate organic ingredients. The British Government advises that if introduced here, the regulation would have the effect of bringing our production requirements for organic pet food into alignment with production requirements in Britain. This is because prior to this regulation, pet food produced here needed to be made with 100% organic ingredients, whereas the requirement for producers in Britain mandated only 95% of organic ingredients. The explanatory memorandum emphasises the Government's position that we continue to have unfettered access to the UK internal market and notes that the regulation, if adopted, would enable producers here to use a single standard when producing and marketing organic pet food, removing the need for them to have to apply more stringent standards than their competitors in Britain. This view is again reinforced further into the explanatory memorandum, where DEFRA notes that they would not expect any material impact on trade except for a limited positive benefit from the creation of a common standard for organic pet food production. In the explanatory memorandum, DEFRA also explains that if the regulation was to apply here, their position is that it should not apply to pet food moving here under the NI Retail Movement Scheme, as existing arrangements with the EU allow for recognition of comparable rules in this regard. They do note that this position would be subject to engagement with the European Commission. The explanatory memorandum outlines business impacts, identifying local producers may benefit from the more flexible approach to classifying organic pet food products set out in the regulation, which brings the EU regulatory framework in line with the rules applied in Britain and therefore would have the effect of creating a common production standard. DEFRA have explained that the potential impact of not adopting this regulation is that our local businesses could be placed at a disadvantage relative to competitors in the south of Ireland, who would automatically be able to take advantage of greater flexibility provided by this EU law when marketing their products across the EU. DEFRA also draws our attention to the fact that there have not been any concerns raised about this regulation during their engagement with relevant organic certification bodies, pet food, trade associations and manufacturers here. They also highlight that the majority of producers of organic pet food in Britain are already complying with the requirements of this regulation in order to produce goods that can be sold in both the British and EU markets. In summary, the regulation relates to a comparatively very small and defined area of trade and business, and its impact in any direction should not therefore be overstated. However, in the event that the regulation was not adopted, we would expect the impact on trade to be negative from the perspective of both internal trade and trade between us and the EU. In respect of local businesses trading with the EU, there is a risk that they could be placed at a disadvantage relative to businesses in the south, who would automatically be able to take advantage of the greater flexibility provided by this EU law when marketing their products across the EU. So we have jointly tabled this motion to allow the Assembly to debate and vote on the addition of this regulation to the Windsor Framework.
Philip McGuigan.
I just want to begin by making a few brief remarks as Chair of the Democratic Scrutiny Committee. At its meeting on the 21st of March, the Windsor Framework Democratic Scrutiny Committee considered correspondence from the British Cabinet Office indicating that the European Commission had confirmed its intention to seek to add the Act to the list of EU laws applicable here under the Windsor Framework through the Article 13.4 Joint Committee process. Further, the correspondence indicated that the Assembly would be formally notified of the Act subsequent to further discussions with the European Commission at the earliest opportunity. So, although the Committee doesn't have an explicit function to carry out inquiries or any other scrutiny in response to a notification that a new Act has been published, the early alert from the British Cabinet Office provided time, albeit limited, for the Committee to gather evidence on the impact of the Act. Specifically, the Committee requested a written departmental assessment of impact. We also heard oral evidence from departmental officials, and we sought views from key representatives of businesses and civil society identified as being affected or who would be affected if the Act is added to the Windsor Framework. Subsequently, a letter issued to all MLAs informing them that the evidence gathered was published and available on the committee webpage, and I hope that members found that useful in preparing for today's debate. Ceann Comhairle, just a few additional comments as a Sinn Féin MLA. Obviously, Sinn Féin will be supporting the applicability motion. This regulation extends the labelling and production requirements that are in place for organic food for human consumption and livestock feed to organic pet food. Prior to this regulation to be considered organic, pet food needed to be produced with 100% organic ingredients. Under the new regulation, to be labelled organic, pet food will need to be produced with at least 95% organic agriculture ingredients. And whilst currently there are no producers of organic pet foods in the north, obviously that could change in the future, and this legislation could actually encourage that position, as producers in the north would benefit from greater flexibility, as pointed out in the explanatory memorandum from DEFRA. No businesses or trade associations have raised any concerns with this regulation. So, in conclusion, Ceann Comhairle, quoting from a DAERA official who presented to the Democratic Scrutiny Committee, there appears to be no downsides to this. In fact, it would make sure that if there were producers of organic pet food here, the implementation of the Act would align the position with GB and with the position across the EU.
Matthew O'Toole.
Thank you. Thank you very much, Mr. Speaker. I will speak briefly, uncharacteristically briefly perhaps today, on this matter, simply to say that the SDLP, the opposition, will be supporting today's applicability motion. The previous Speaker, Philip McGuigan, the Chair of the Democratic Scrutiny Committee, outlined the fact that no trade bodies had raised any objections to this. There are indeed, in terms of practical outcomes, no currently organic pet food producers in Northern Ireland, but clearly our view is that the continued delivery of, or the continued realisation of the benefits of dual market access do require us to be able to maximise that dual market access and that ability to export seamlessly into both markets, given that it is clear that there doesn't really appear to be any downside for not producers, because there aren't any producers of organic pet food here at the minute, but any future producers, there seems to be no good reason for us not to agree to this new law applying to Northern Ireland. I won't go much further, Mr. Speaker. I was thinking of saying that Northern Ireland pet food, should it be produced at an organic level, would be of a very fine pedigree, but of course that would be a pathetic pun trying to lighten the mood in the Assembly. But other than that, Mr. Speaker, we support this new law going forward. We think it's important that we have the ability to debate this. We have always said, whenever there was debates about changes, improvements to the protocol, what is now called the Windsor Framework, that we were happy to acknowledge that it was good to have increased scrutiny. I think that's what's happening in the Chamber today. We will be supporting this applicability motion. Thank you.
David Brooks.
And likewise, the Democratic Unionist Party will be supporting the motion before us today as well. In restoring these institutions for the good of Northern Ireland as a whole, we sought to restore unionist confidence by ensuring the concerns of our community were heard and systems put in place to protect our trade within our own UK borders and protect our place in the UK single market. We have successfully delivered the changes to Article 13 of the Protocol to give locally elected representatives a say on whether new or amended EU laws should apply in Northern Ireland, and have seen already that the applicability motion mechanism has allowed unionist representatives at this Assembly to vote against the adoption of EU rules relating to non-agricultural GIs. The issues with new EU legislation on dental amalgam are already well documented in the press, and should no reasonable accommodation be reached with Brussels in the meantime, I suspect it is likely available mechanisms will be used to object to those rules as well, ensuring our ability to remain aligned with UK rules, which in that case are clearly not only beneficial but also absolutely necessary. However, this party has said we would use this mechanism not on every piece of forthcoming legislation, but with reference to impact of relevant legislation upon the people of Northern Ireland. This piece of legislation brings us into line with UK rules. To vote it down would be punitive and fruitless. It would not in any way lead to the removal of all EU law. Speaking personally, such a removal would be desirable, but it will not be attained by any vote today. And deliberately voting for an outcome that would have the effect of, at best, forcing continued divergence with GB on that basis is irrational, and those shouting from the sidelines have no plan, only rhetoric. From what I can ascertain, our detractors agree that the outcome is desirable, but the route by which we get there is objectionable. I understand that. Indeed, I don't disagree in sentiment, but where I do not agree is in arguing that we should willfully prolong needless, even potentially economically harmful, divergence with the rest of the UK, knowing that to do so would not result in any move from the UK Government to rectify the same. We recognise that some EU law remains in Northern Ireland. Some try to misrepresent our position on this when we have been clear. We argued that the people of Northern Ireland, through their elected representatives, must have a say in the laws governing them. While removing EU law is desirable, the DUP have focused on tangible practical outcomes and on preventing regulatory borders from emerging. The DUP have made it a key objective that the democratic deficit created by the protocol, to tackle that democratic deficit created by the protocol. This debate is further evidence of our success in giving the Assembly a meaningful say over future laws that apply in Northern Ireland. The safeguards against future uncontrolled divergence this party delivered were a step forward from where we began the process of negotiation. At no stage was it argued to be perfect, rather that we would bank that progress and work to build upon it. I recognise that at times it is complex and convoluted. I suspect none of us who sit on the Democratic Scrutiny Committee would argue with that, but it has given the unionist population of Northern Ireland safeguards which we did not previously have. It has extracted concessions from the UK Government and from Brussels that they would not previously give, and our detractors said that they would not give. Indeed, it was said that they would not negotiate at all. The detractors have no plan. They have never offered an alternative roadmap forward. They can certainly articulate idealism, even in many cases in terms that would be desirable to many of us on these benches, but they offer no means in which, in today's Northern Ireland, those ideals can be delivered. It is this party that is willing to lead, willing to make the difficult decisions, and willing to do what is required to move beyond stirring but empty words to deliver tangible progress. Thank you, Mr. Speaker.
Owen Tennyson.
Thank you, Mr. Speaker, and like others, I intend to be uncharacteristically brief when it comes to this motion. My party's overriding economic priority throughout the Brexit process has been to protect and uphold Northern Ireland's dual market access, giving us a unique and privileged competitive advantage. Sustaining that dual market access will require parties to take a pragmatic approach to applicability motions and to democratic scrutiny more broadly, prioritising the substance of motions over party politics or ideology. If we are to take full advantage of the opportunities before us, we owe it to our business community to offer the maturity, certainty and stability which they so desire. It is in that vein, Mr Speaker, that I rise in support of the motion, and at the outset I want to welcome the fact that the First and Deputy First Ministers have managed to jointly table the motion on this occasion. It is a genuinely positive step, and I believe I hope that we have crossed the Rubicon in terms of our approach to dealing with EU law, which is important, albeit technical, in this instance. Organic products are a highly regulated area, and in order for a product to bear an organic logo, it must be subject to a fairly robust process. The motion before us is about a very specific area in terms of organic pet food, and in effect provides additional flexibility to producers, so that products containing 95% organic ingredients can be marketed as such. Whilst there are no pet food manufacturers in Northern Ireland currently registered as organic, we have to be cognizant of the fact that there may well be those who wish to enter the market in future, and this regulation guarantees them that additional flexibility. Not only does it bring pet food in line with standards for human food and livestock feed, which I think sounds eminently sensible, it also enhances alignment across these islands, moving us to a common production standard across the UK and EU to ensure that any pet food producers who seek to operate from Northern Ireland will continue to have the benefit of accessing both markets. Again, a huge advantage. Small in some ways, but not insignificant, and something which I think we should all be advocating for. In closing, Mr Speaker, I just want to say that it is, however, a matter of regret that, again, applicability motions are another element of Assembly procedure which are subject to cross-community vote. We talk on numerous occasions when it comes to Brexit about the importance of cross-community consent, but I'm conscious that the people that I represent aren't properly included in that process, and so that's an issue which, certainly from my party's perspective, we will continue to articulate and raise concerns about, but happy to support the motion today. Thank you.
Dr Steve Hagan.
Thank you very much indeed, Mr Speaker. And may I congratulate the First and Deputy First Ministers for taking an interest in this applicability motion as it's come forward. Members will remember the last applicability motion that came before this chamber, and I raised several questions from this floor about when somebody was going to take ownership of that applicability motion, and nobody ever did up until the last possible minute, and it was rejected rightly. On this occasion, the Ulster Unionist Party will be supporting this motion. We'll be supporting this applicability motion because to do otherwise would create a divergence from the rest of the United Kingdom. And in the complexity that is EU rules and regulations, members need to realise that on some occasions we cannot be seen to be diverging from the rest of our nation, and it's important that we recognise these issues. Mr Speaker, members will realise, and also those other members of, and I welcome Mr Tennyson to the Democratic Scrutiny Committee. Members will realise that I've raised in the Democratic Scrutiny Committee on several occasions the point of us not being curious enough about regulations that are coming forward. And I'm glad to see that our committee is now taking a more proactive approach. And indeed, we've already heard the issues about the dental amalgam, and I do hope those issues will be raised in the joint committee and we don't get to the point where we have to debate this on the floor and the issue will be sorted before we go ahead. I will encourage the committee and the chair of the committee and the rest of our committee to remain curious, because there are many elements that are coming through at the moment that are going to challenge many members of this chamber, not just on an inter-community basis, but for all of us and where we're likely to be. I think it's important that we continue to do our horizon scanning of what's going on. And indeed, I'm glad the First and the Deputy First Ministers are here, because I think they need to look very closely at how we resource what we're doing. We need to ensure that our office in Brussels is ready to be able to interact as legislation's coming through. We also need to make sure that we've got sufficiently well-trained staff within the Northern Ireland Executive, and indeed supporting the Democratic Scrutiny Committee, who actually understand these legislation and these rules as they're coming through. And as a way of warning, First and Deputy First Ministers, I've been in communication and conversation with our friends in Norway, who have a lot of difficulty in dealing with EU rules and regulations, even though they have to accept most of them. And I also took the matter up with a senior Estonian politician recently, who said exactly the same thing. So we need to be more proactive. We need to look at how we resource these things, and we need to be prepared to work closely with all stakeholders to make sure we understand the challenges we are about to face. But once again, I congratulate the First and Deputy First Ministers for actually taking ownership of something, and of that we should all be grateful. Thank you.
Jim Allister.
Mr. Speaker, the primary focus of this debate to this point has been on the content of this EU law. I want to shift the focus to the much more important issue of the constitutional affront that this motion is. And the constitutional affront can be summarised in this way. What this motion amounts to is an acknowledgement and assent to the fact that in what patently is a devolved issue, namely how we prepare animal foods, that only the EU can now make those laws for us. That this Assembly can't legislate on this issue, that the Westminster Parliament cannot legislate for this part of the United Kingdom on this issue. Only a foreign jurisdiction, the EU, can formulate and pass laws touching upon this issue. And not just this issue. Of course, every issue that is recited to the tune of hundreds of laws in Annex 2 of the Protocol. So the real constitutional affront that some don't want to face up to, that some embrace, of course, because they want to see Northern Ireland subjugated under the EU. But those who claim they don't, the issue they're not facing up to is that here we have a situation that a pretty mundane law can only ever now be made by a foreign parliament. Cannot be made by the Parliament of the United Kingdom, cannot be made by the Northern Ireland Assembly, can only be made by a foreign parliament. And the motion's well named as an applicability motion, because by our slavish acceptance of it, we are giving assent to the applicability of that appalling and absurd situation, that only a foreign parliament can legislate for this area of law in Northern Ireland. That is what this Assembly is being asked to assent to. And that, to me, is so constitutionally absurd and such a constitutional affront that, frankly, I cannot and I will not support it. And isn't it the ultimate absurdity to be told in this debate by the DUP, the party that told us, in the words of Sammy Wilson, there should be no EU law applying to this part of the United Kingdom, repeated by then leader Sir Geoffrey Donaldson, repeated by multiple members who sit in this House. EU law was a red line, we were told. It should not be applied to this part of the United Kingdom, we not being part of the EU. And yet today, the DUP has come to the point, or at least those of them that are here, and I think there are some noticeable absentees, has come to the point that they tell us that the only way to attain parity with Great Britain is to vote through this EU law. Think of it. The only way to get parity with Great Britain is to vote through an EU law, because this EU law just happens to bring the EU into line with Great Britain. Now, it may well be sensible for the EU to reduce its unattainable 100% organic requirement. It may well be sensible for it to come into line with the 95% that prevails elsewhere. But when it comes to Northern Ireland, it should be this Assembly, or at least Parliament, that's making that decision, not this foreign Parliament of the EU. And we're told there's no downside. Sorry, there is a huge constitutional downside. And those who roll over, as they have, and assent to that, are showing their disregard for that constitutional front and, of course, for their own previously unalterable position, we were told. And they say, oh, if you don't vote to this, there'll be divergence. No, there won't, because we know from the explanatory paper the British government's going to assent to this anyhow. But we're going to give them the cover. But what about tomorrow? What if GB decides in further deregulation that it will deregulate below 95%? That it will go down to 90%? And remember, the British government is presently conducting a review of all its organic legislation. There's no publication of that expected to the end of 2025, but it's subject to review. What then? What if GB goes to 90%? Well, hapless Northern Ireland, supposed integral part of the United Kingdom, remains trapped in this EU law, remains subject to this 95% delineation. So there is no assurance of parity here. The only assurance here is of subservience to a foreign parliament. And that, sadly, unsurprisingly for some, but surprisingly for others, is where the DUP and the Ulster Unionists in this House have got themselves to. And of course, what they're embracing is, for any such product that was ever produced in Northern Ireland, it wouldn't be labelled as produce of Northern Ireland. Article 4 of the regulation makes it very clear. It would be labelled with the EU logo and labelling, underscoring the fact that we are that subservient part under EU law. This is a situation where Northern Ireland, a part of the United Kingdom, is being subjected to colonial EU law. Law we didn't make, law we can't change, but which today we're invited to slavishly endorse. Endorse colonial rule from the EU. They made the law. It's their law. It's not ours. It's a law we can't change. And regardless of the merits or the demerits of the content, it does not deserve democratic assent from anyone who holds the fundamental democratic principles that when you live in a place you should be able to make your own laws, not be subjugated to the laws of a foreign power. And so I will not today give my consent, and I wasn't sent here to give consent to colonial EU rule, and I certainly will not be giving consent to it. DUP made that mistake on the 8th of December 2020, when they blindly, foolishly, in face of warning, embraced 45 different EU laws, including the one that says You can't bring British soil into British Ulster. And they bolted it onto the statute book. Sadly, today, we're going to have a repeat performance. And one will be interested to see if we get a vote as to who doesn't vote for this. As I pointed out, I noticed some notable absentees from the divided DUP benches. I just wish they had the courage to vote against and stand up against EU colonial law and the obscenity in the affront that it is imposing upon, I suppose, democratic assembly. Thank you.
And call the Deputy First Minister, Emma McKenna, to wind on the motion.
Thank you, Mr. Speaker. I would like to take this opportunity to thank you, Mr. Speaker, for sending the First Minister and myself the formal notification and for members' comments and input to the debate on this applicability motion. The case setting out the arguments in relation to the measures contained in Regulation EU 2023-241 being added to the Windsor Framework are set out clearly in the UK Government's assessment and its explanatory memorandum accompanying the notification. Members will be aware in some way now of the procedure, having debated the previous, but for an applicability motion to pass, it must receive cross-community support as outlined in Section 4(5) of the Northern Ireland Act 1998. If this threshold is met, the Assembly will have been seen to agree to the addition of the regulation to the relevant annex of the Windsor Framework, and this will be adopted at the meeting of the UK-EU Joint Committee. If the applicability motion does not pass, the UK Government will veto the addition of the Act of the Windsor Framework of the Joint Committee. I do believe this section, Mr. Speaker, is still misunderstood by some, because if the applicability motion does not pass, the UK Government will veto. However, they can agree, but only if the Minister considers that there are exceptional circumstances or that adoption would not create a new regulatory barrier between Northern Ireland and Great Britain. These were the new arrangements, Mr. Speaker, under the Safeguarding the Union paper. Proposing to add a new rule to the Windsor Framework on that basis, that it would not create a regulatory border or because there are exceptional circumstances, a UK Government Minister must make a statement to Parliament before doing so, explaining why they are of the opinion that either of those conditions have been met. The UK Government must have also indicated in this scenario they intend to notify the Assembly of that decision. Just to respond to some of the members who have made comment during the debate, Mr. Speaker, the cop-out thing to do in relation to this issue would be, in my view, to vote against the motion and to leave it to others and to make those decisions, but with us having no say and no role here in the Assembly. Speaking personally in relation to my party position, that is exactly why we fought for and secured new mechanisms to give this place a meaningful say in relation to the matters that impact the people of Northern Ireland. In particular, those mechanisms were designed to ensure that the members of this place had a significant role in relation to stopping potential future divergence. Indeed, when you look at the explanatory memorandum in relation to this matter before us today, published on the 4th of April, it makes it clear that adopting this regulation would lead to a common production standard across the UK, would avoid NI producers having to abide by a more stringent and costly requirement than firms in GB, would not impede unfettered access and marketing of NI produce in GB, would reduce burdens on local producers in the development of their product ranges, especially in terms of sourcing of ingredients, and would not affect organic pet food that is made to UK standards being sold and circulated in Northern Ireland. We have heard some members refer to the constitutional position in relation to this matter. I believe firmly in the principle of UK parliamentary sovereignty. Indeed, I understand that the member who has just recently been speaking on this in this debate also does so and agrees with my position that the UK Parliament can legislate if they so wish to do so. But this debate today and the position taken by myself in relation to this matter, I'm going to finish the point, please, The matter in relation to what we are considering here today relates to an existing provision in Annex 2. Annex 2 applies in Northern Ireland through the Windsor Framework, and before that in terms of the protocol arrangements, not because they were imposed by the EU, but, in my view, sadly, because the UK government and our UK sovereign parliament has agreed that the law set out in Annex 2, those laws and regulations apply to Northern Ireland. And our UK sovereign parliament sets out that the mechanism in relation to changing that is in relation to the EU proposals being amended or new law to replace. Now, as the member is fully aware, under the Windsor Framework, there was no democratic accountability for this place in relation to that decision by the UK Sovereign Parliament in relation to the laws that apply here. And that is why these new mechanisms in relation to applicability motions and the Stormont break were brought in. They were brought in, again, personally speaking, in relation to my party, because we highlighted the absolute appalling democratic deficit in relation to rules and regulations through a mechanism agreed by our sovereign UK Parliament being done either automatically in the case of amended law or in relation to new law decisions by the UK and EU sitting in the joint committee. It was my party that pushed for these mechanisms to be put in place in order to allow this place to debate it, not because we embrace the concept of Annex 2, not because we agree with our UK Sovereign Parliament on this matter. Indeed, we did not. We voted against it, we have spoken against it. But unlike some members in this chamber, I accept a legal reality of where we are. And the one thing absolutely I will always do is to put Northern Ireland first and to ensure that Northern Ireland will not be left behind when the rest of the UK moves to a different position. I will not allow Northern Ireland to be in the position where there is an internal regulatory divergence in relation to new or amended law. Now, ideally, is this the way that I would like it to be done? Absolutely not. And I have been very clear on many, many occasions that this is not the way that I would choose to do these things. But there is no, quite frankly, pathway set out here by any member or by the UK government at this time in relation to this issue. Therefore, we are exercising the mechanisms that we pushed for, that we secured, that this House now has that meaningful role in relation to looking at these to ensure primarily that what is being done does not create a new regulatory barrier. If indeed we voted against this, Northern Ireland would be the only place across this United Kingdom that would be stuck with the old rule. And I think it's important to clarify for people out here that this is not a new and additional. This is a replacement. And if this was not applied in Northern Ireland, the existing would apply that would put us in a different position than the rest of the United Kingdom. Mr. Speaker, politics is about hard decisions. And I did want to stand here today to explain why it is, of course, the right thing to do to make sure Northern Ireland is not left behind. Today, this will be a hard decision for many people because we do disagree with the approach taken by the UK Sovereign Parliament in relation to these provisions. But those are the provisions that we are currently operating under, and therefore we are prepared to make those hard decisions on behalf of everyone in Northern Ireland to ensure that there are no new regulatory barriers across this United Kingdom. The debated regulation relates to a very small and defined area of...
The member has clearly decided not to give way. I'd ask the member, I spoke last week on this, that members shouldn't continue after 2 or 3 times. If the member chooses not to give way, not to keep chundering from the sidelines, and I appreciate if members would observe that.
Thank you, Mr. Speaker. I do believe that the member may make some point around the constitutional position, but the reality is that the UK Sovereign Parliament can decide to make regulations for Northern Ireland if they so choose. They have chosen this mechanism which we're operating under today. The debated regulation relates to a very small and defined area of trade and business. In the event it was not adopted, we would expect the impact to be negative from the perspective of both internal UK trade and NI-EU trade. It is therefore our jointly agreed view in the Assembly that the Assembly should agree to the addition of the regulation debated today to the relevant annex of the Windsor Framework. And this, Mr Speaker, is a demonstration today of the democratic scrutiny mechanisms and the role that this place will have to play moving forward to ensure that free flow of trade. Thank you.
Before we proceed to the question, I advise members that this motion requires cross-community support. The question is that the applicability motion standing in the order paper be agreed. All those in favour say aye. Aye. Contrary, if any, no. 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 Clear the lobbies. The question will be put in 3 minutes. Order. Members resume their seats. The question is that the applicability motion stand in the order paper be agreed. All those in favour say aye. Aye. Contrary, if any, no. 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 Do we have tellers? Tellers have been appointed as follows. Tellers for the ayes are David Brooks and Philip McGuigan. Tellers for the noes are Jim Allister and Alex Easton. Clear the lobbies. The Assembly will divide. Ayes to my right, noes to my left. Secure the doors. Order. Members will resume their seats. Clerk, read the result.
74 members voted, of which 72 voted aye, 97.3%. 32 nationalists voted, of which 32 voted aye, 100%. 26 unionists voted, of which 24 voted aye, 92.3%. 16 others voted, of which 16 voted aye, 100%. The motion is carried by cross-community support. If members would take their ease before we move to the next item of business.